Okay, so AB 2253 by Assemblymember Lowe, basically there are certain state settings where a license is not technically required by our licensing law. However, a lot of state agencies require it by law anyways. So basically they have an exception if you are gaining, their law says if you're gaining qualifying experience toward licensure, that you don't have to have a license even if you even if it's required for a certain period of years. So basically, if you're gaining qualifying experience, you can work for X number of years. However, it's come to the attention of the author that certain state agencies are interpreting what qualifying experience is differently. So this bill doesn't really affect anything that our board does, but it does affect the employment of some of our license type or our associates that are working toward a license. And so that's why we're considering it today. And some examples of these state agencies that have this kind of clause in their law are state health facilities, the state correctional system, local community mental health programs. So those are the kinds of agencies that we were talking about. So basically, this bill, it defines qualifying experience or experience required for licensure as experience that satisfies the requirements of the specified licensing act regulating the profession. So if they're a registered ASW, qualifying experiences would be requiring experience that our licensing act requires in order to gain licensure. The author states that they're trying to clarify the definition of a qualifying experience. There was a discrepancy in how overseeing agencies define qualifying experience. So I asked for a little bit more specifics on this, and they told me that the State Department of Corrections and Rehabilitation recently suddenly interpreted existing statutes differently than many other state agencies do, and they changed how they calculated the time for purposes of licensure waiver. And this resulted in 2019 in CDCR issuing dozens of non-punitive terminations of employees who believed that they still had time to apply for licensure before losing their jobs. So they're just really trying to clarify what constitutes qualifying experience, that it's experience of the applicable for licensure from the applicable licensure board in order to continue working under that exemption. And so I will open this up for comment.
I'm not hearing any negative impact at all. Roseanne, is there any impact for us that you can see?
No, it's more of a, I included this so that so the board can consider supporting its associates that are working in state settings.
Can I have a comment from Leah?
I think my brain is fuzzy. Okay. So the way that I'm not getting the details of it in my brain. So the way that it's languaged in this bill is to protect our registrants or associates. Yes.
Yes.
Okay.
Yes. Basically, different state agencies, they have an exemption. Registrants are allowed to work at various state agencies without a license for a certain time if they're working toward licensure. But the state agencies were basically interpreting in different ways or changing their interpretation of what working toward licensure is. And so that was causing people to lose their jobs. So the goal of this bill is to make it consistent across the different state agencies, if that makes sense.
Christina?
So it seems to me that, this bill is really to close some of the unclarity or some of the practice by the CDCR, because yes. It seems like the amendments coming are from the Health and Safety Code, which we really not quite related to normally our Practice Act, and so I'm kind of with Leah. It's like what is that? How does that I'm glad you related that about that protecting the associates and the trainees and that kind of, that type of license registrant. So, but at the same time, the impact to us, to our, it seems like, it's just basically it's like you accept, it just seems to me, I don't know quite, I get it, but it seems it's just kind of unclear, just what, that we are, how it relate to us. But thanks for clearing.
Yeah, it's one of those bills that does not affect, it doesn't affect directly our license types or necessarily, but it's one of those bills that does kind of skirt on the issue. So we bring it before the board so that the board knows about it. And if the board would like, the board does not have to take a position on it. You can just choose to watch it. But we felt that it was close enough. It affects some of our professionals that it was worth at least bringing it to your attention.
Mm-hmm.
And then John?
So if everyone is okay, I would actually like to move to support.
I'll second that.
Okay, there's no public comment.
Okay.
Call for a vote.
Yes. Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Desposti?
Yes.
Susan Friedman?
Yes.
John Sobek?
Yes.
Wendy Strack?
Yes.
Christina Wong? Yes. My motion carries.
All right, moving on to AB 3045. The author is Assemblymember Gray, and this bill discusses Department of Consumer Affairs boards, veterans and military spouse licensure. It would require certain boards within DCA, including this board, to issue a license to an honorably discharged member, military member, or spouse of an active duty military member if they meet specified requirements. So certain boards right now under DCA, not including BBS, are required to issue temporary licenses to a spouse of an active military member who's licensed in another state. And then for other boards, the law, including for BBS, the law requires us to expedite the initial licensing process for an honorably discharged military applicant or spouse licensed in another state. In order for a license to be expedited under current law, the military spouse must hold a current license in another state in the same profession. We also have in our law, effective this past January 1st, we have our licensure by credential process for LMFT, LCSW, and LPCC applicants, where those licensed in another state can obtain a California license through a streamlined process if they have a license in the other state that's active and unrestricted, held for at least 2 years at the highest level for independent clinical practice. If they have a qualifying master's or doctoral degree from accredited or approved school. If they submit fingerprints, they need to also pass certain California-specific continuing education courses in law and ethics, California child abuse reporting, and California cultures. And then finally, they need to pass the board's California law and ethics exam. And that was a new process, just like I said, put in place this past January due to the work of our License Portability Committee. This bill would require a board within DCA that's not required to issue temporary licenses, which is this board. We don't have that requirement, so this bill would apply to us, to, after appropriate investigation, issue a license to an applicant who can provide evidence that they are honorably discharged or married to a domestic, or married in a domestic partnership with an active duty of the armed forces. If they hold a current active and unrestricted license in another state for the same profession. If they submit an application to the board that includes a signed affidavit, they meet all requirements for licensure. If they submit verification from their licensing jurisdiction that they're in good standing. If they had not committed an act in any jurisdiction that would be grounds for denial, suspension, or revocation. They have not been disciplined in their licensing by their licensing entity. And if upon request, they submit fingerprints to us. And it also states that our board can adopt regulations to administer provisions of this law. So what the author is trying to do here is that they're stating that military families are, of course, disproportionately affected by occupational licensing barriers because they're moving from state to state, and it's not always easy to obtain a license in a new state. They state that past efforts to reform the licensing process for veterans and military spouses have stopped short of creating license portability. And many other states have laws that are more veteran friendly. One big issue to point out with this bill is that we recently implemented our licensing portability legislation. We call it licensure by credential. The creation of that licensure by credential was a result of a really lengthy and carefully weighed deliberation process by this board. And the board really considered how to balance ease of licensure across state lines with public protection and need for practitioners to be prepared to practice in California's diverse environment. So there's some differences in the bill we're considering today, AB 3045, and it makes some key omissions of requirements that were carefully considered in our portability bill. It does not require military applicants to have been licensed for at least the past 2 years. It does not specifically state that the out-of-state license must be at the highest level for independent clinical practice. That might be important because some states have licensure at varying levels that does not match up with this board's levels. It does not require any California-specific coursework, such as California cultures or California child abuse laws and reporting. There's no requirement for the applicant to take the California Law and Ethics exam, and it doesn't say anything about paying fees, although we think that that's an accidental omission. And when we did the fiscal in this, we were asked to assume that they would be paying fees. So given that the care that the board took with SB 679, which is our portability bill, to create a fair process to reduce barriers, balanced with the need for public protection and training in cultures in California, I think the discussion today you might wish to focus it on if SB 679 is sufficient to assist military applicants, or if additional accommodations like what are provided for in this bill are necessary. One other thing that I want to bring up is the bill would also require the board to issue a licensed educational psychologist license to an applicant licensed in another state. Our portability bill did not include LEPs because it's a fairly unique license. The only other state that has an LEP license that I was aware of, it was Massachusetts, and I reached out to CASP, the California Association of School Psychologists, to see if they were aware of any others, and they stated Massachusetts is the state they're aware of that has a similar license. In Massachusetts, LEP license is a master and doctoral degree, 60 graduate credit hours and 1,200 practicum hours, 2 years supervised experience as a school psychologist, and passage of the National School Psychology exam. And in one of the attachments, I've included the Massachusetts requirements in case you're interested. So that's what's before us, and I will open it for discussion.
We have Max has a comment.
Oh, please forgive me, because I think today I reached the record of 6 hours on Zoom, something like that. But so thank you. I think I towards the end you kind of like made a parallel with the portability license. So I was struggling to understand how this bill is out. Why is not included in portability license, and why it's an exception in some ways, number one. And then the two, because we know also, we had this conversation before, the expectations in California compared to many other states and license, the requirements, are a little bit higher in relation to cultural competency. So in these specific states, when it comes to that, what are the protections for the public in relations to, for instance, coming from a state that doesn't require that cultural competency, or maybe a state that's still practicing reparative therapy, or maybe, so I want to know if those are issues that we already addressed on this, so I don't want to go over if we did, so I'm just missing something here, so I apologize if that's the case. Thanks.
The reason, when the board did SB 679, the reason that the 15-hour California cultures course is included in there, and also the California specific law and ethics course requirement, was because of those concerns, because different states have different cultural environments that are not the same as California. And so it was felt that the 15 hours of coursework for the California cultures would help, and the California law and ethics requirement as well would help, help those licensees that are coming in to be familiar with the environment that's in California.
I have a comment from Christina.
So Roseanne, it looks like this bill is not really applicable to all the boards, right? Is it only certain boards?
Only boards that are not required to issue a temporary license. And our board is one of the ones that are not required to issue a temporary license. So they're basically putting a portability type requirement on us instead of requiring a temporary license.
Okay. So, I think how do I phrase it? So it seems like, we do have the license portability bill in front of us. And so I wonder if that would be more prudent to actually, support the bill, but excuse BBS, out of that, that requirement. Because, I think what we have really suffice to, we set a standard, to make the license, easier to, to cross, for the licensee to, come to California to work. But at the same time, because of the LEP issue. So if we were able to just excuse our board, that might actually resolve, some of those concerns.
So would you want to exclude the board from the 3 and leave it for LEPs?
No, I think, just to entirely, not including our board, within that DCA certain boards categories.
I think if we were to ask for our exclusion, I don't know that it would be advisable to still support it because it wouldn't pertain to us anymore. Does that make sense?
Yes.
It would kind of be saying, well, but this other board should because we don't really know what they have or don't. But for us, we could make an argument, hey, we just passed SB 679. It does this and this and this. Therefore, we've addressed the issue after much deliberation, and this makes sense for us.
Right, and that's I think we can definitely talk about the position, but I really think that with the AB 679, we're able to address that portability issue, and so I don't know if it's more prudent to oppose it or whatnot, but I think that just that we have the mechanism in place already. So
we have. Oh, sorry, Kim. Did you want to make a comment, Kim?
Just a brief comment along Christina's lines. I think, and Rosanna Sabina, correct me if I'm wrong, this bill actually lowers what we require currently under SB 679. And I think that just as we definitely need to have that conversation with the author because it's undermining what we've done.
Yeah.
So Sabina, in terms of position, is it support if amended or just straight up opposed?
Yeah, it's hard because you guys are the people with the license portability language, and they refer to it and they say, oh, like no good license portability language is out there, but you guys have it. So you can definitely do something like that to ask yourselves to be carved out as an exception in the bill, and you can maybe Roseanne can have that conversation showing, look, we already have license portability. We are one of the few, and this is gonna, it's in direct contrast with our requirements for our license portability.
I wouldn't recommend a straight oppose because that kind of implies that there's nothing that they can do to fix our opposed position. The position that would have the most teeth would be an oppose unless amended. That would really get their attention.
Right.
This is
exactly.
You want to be a little careful because this is a military bill, and of course, I think the board in the past has been very supportive of military issues regarding the licensure, but this would have a serious impact on the work that we've just completed.
Mm-hmm.
I have a comment from Leah.
I would add to that, Roseanne. The serious work is one piece, but it actually puts the practitioner and the public at high risk without having the cultural competency and, most importantly, understand the laws in California. Having been licensed in 2 different states, the laws are incredibly different from state to state, and I would be really sad if clients were harmed because they didn't get that legal course and take the law and ethics exam as a prerequisite to it. So I was thinking all along oppose unless amended to remove the BBS.
Betty? Unmute. Sorry. Oh, Betty? Oh, yeah, you're. Oh, there you go.
On it.
Oh,
There we go. I had my participants on that corner.
Oh.
I don't know how to address this because I agree with what everyone is saying, and I think that makes the most sense. But I'm also really sensitive to the climate right now, which is increased portability, support the challenges that our military is facing. I mean, I just want to make sure that we craft this in such a way that it doesn't come off looking like we're not incredibly sensitive and supportive of the issue of portability and making things as easy as possible for people that are facing challenges.
I have a comment from John.
And I'm kind of leaning the direction Leah is. The one thing that comes up for me is the idea that what I read in the bill is it addresses legal issues of portability, but it doesn't address ethical or educational pieces of portability. And especially in the work that we do, there are huge things that a clinician coming into our state would need to know that are unique to our particular profession here. And the bill we've crafted for portability addresses those on so many deep layers. And I just think we are walking a tightrope here of not saying that we actually already have a process in place that has a very high standard and yet is also very accessible. And that's why I think either a carve out or some type of amendment would be really important if we are doing any support for this bill.
Sorry, comment from Max?
On that note, I agree. I'm just wondering technically if we oppose, if we agree unless amended, I mean, the whole purpose of this bill is to speed up the process. So it's kind of like taking away everything that they wanted to do, which I stand by my position. I wouldn't feel comfortable, to be honest, for the reasons I shared before and other added. So perhaps I would say, because definitely, Betty, we don't want to send out a message that it's, of not opening and not allowing people to reduce some of the barriers, but those are barriers that are really important. It's not just hours. It has to do with quality of services it provides. It could cost the life of a client. So I would say I'm okay with what Leah was saying. I was just wondering for Roseanne if technically will make sense, because it kind of like feels like we're pretty much asking them to modify an aspect of their bill that's the essence of that bill. I don't know if I'm making sense, but I'm okay with that proposal anyway.
Kim, did you want to?
Let Wendy go first because she had a comment
Okay,
as well,
very
and then
good.
I'll speak after Wendy.
Wendy, go ahead.
Okay. I guess I just kind of had a question about how to proceed. I'm very sympathetic to the concerns that Betty raised, and I think I'm not sure I'd be totally comfortable opposing a bill that the intent was good to help veterans, in some of their, as they move throughout the country. So I'm not sure I'm really super comfortable with an oppose unless amended position. I was just wondering logistically if there was a way to like seek an amendment or request amendment without really having an oppose or support position. Is there a way to sort of neutrally look for an amendment? Maybe even something along the lines of so that the bill applies to boards that either don't have temporary licenses or don't have other portability provisions or something like that, to where we're kind of subtly, moving ourselves out of the bill without really directly saying we don't want any part of this, but to sort of acknowledge that the portability work that the board's done in the past is important and should be considered equivalent to the temporary license work that's done on other boards. And I know I'm new to the board, so this may not make any sense at all, but just trying to see if there's a way to thread the needle there.
And I think that there is actually. Roseanne crafts these letters, especially oppose unless amended the letters, very eloquently, and they're respectful. They recognize the work and the intent of the author, but she has a really nice way of sharing our concerns with the author without being offensive, and follows up with phone calls. So I think we can do this. We've been supportive of military bills in the past, and I think honestly, this is the second bill we've seen like this. The other one didn't make it, but where all of a sudden portability is a huge concern and desire in California, but the authors don't know that we've done this work because they're not familiar with this or for whatever reason. And so I think once we point it out to them, it should be just fine. And I have every confidence that Roseanne can thread that needle really well.
And I always run those type of letters through Kim as well before I send them, just to get a second pair of eyes, and make sure that that it comes across as it was intended. So we are
sure, fun to me.
No, we are. I'm trying to say we are very careful with how we do that, and we don't just kind of fire off something without thinking about it. In terms of saying of not taking a neutral position or taking a support if amended position, it depends on how strongly the board feels about this were it to go through, or if the bill were to go through. Do you feel, are you okay with the requirements in this bill in lieu of what's already required in portability, because it will override it for the military applicants? The author has a lot more incentive to make the amendments rather than ignore them if there's an oppose unless amended, rather than if there is a neutral or a supportive amendment. Not to say they wouldn't, but it's much more of a concern if it's an oppose unless amended, which is why sometimes that needs to be done.
Christina?
Two thoughts. I was about to throw it out there about the possibility of support if amended and maybe do the carve out, and I know that, Roseanne, does have a way to really address the concern. The other possibility is maybe to, to maybe add information about the licensees will still need to meet the requirements of the board. Say meet the higher requirement. I don't know. I'm just thinking about whether it's just possible to address that. If there extra requirement that they need to have, they need to still be in compliance or in consistency with the board's criteria to issue the license. I don't know.
If you actually if you look at my analysis, item 3 under the comments where that bullet point list is there that basically says the difference between this bill and our portability bill. Mm-hmm. Instead of asking for a renewal or removal, we could ask for those specific things, which would basically then make it match portability.
Right.
I would the oppose unless, I mean, it's still, you would have to weigh what kind of position, if you're comfortable with the support position, if they did that, and then a neutral position if they did not. I mean, it's still the same issue of oppose unless amended instead of a support if amended. It doesn't fix that problem, but it is a little softer
Right.
than saying just take us out, rather than saying, well, we want you to do this and this and this and this if we're included. That would be one different approach.
Right. And that's what I'm thinking is like, if, because we really cannot, we should not compromise, the consumer protection, and all the work that we have done. And I guess that this is a good problem, when we're being like the pioneer of the license portability issue with the bill, right? And so, so that's why I'm thinking that maybe, along the line that, that the requirement, that the licensee will still need to meet the requirements for that, particular licensing board, and I don't know how, how feasible it is, because, they can come in the door, but then they just need to, make sure that, they get those classes and, that, all the stuff that done. And I think that the difficulty really is about the 2 years, because, we do have that line, when you have those people, who just licensed for a year, they want to come to California, and then you want to issue a license, and that's just really inconsistent. So I think, the cut cleaner really is about, I would really support the carve out, but, or for whatever way that language that we can bring in, to have them also, to meet those license criteria as a makeup or whatever. I think that would probably be helpful.
Comment from John.
So Roseanne, I have a curiosity. Rather than asking the BBS to be a carve out, what would happen if the language said that boards that already have strong portability language in place become a carve out, and then you share with them the process that we've been through with the other bill? That might be a way to approach it. It's not just us, but it also encourages other boards to look at their portability practices.
That's a really good suggestion. I think that's a great idea.
And then Leah.
So I was thinking along those very similar lines. We would support if amended, and we would amend the language to say that it would meet these criteria, or if they have portability, to match to meet the portability requirements. Does that make sense?
It makes sense. Would you be okay? My response to that would be, if they said, no, we're not going to do that, are you okay with being neutral?
No. Yeah, okay. I really feel like oppose if amended is a better option, and that the amendment, instead of saying, as John said, instead of the BBS, the amendment would say unless a portability, where it puts the portability piece as an excused, or to be excused from this bill, just like the temporary licenses. So any board that already has a temporary license or already has portability. So to amend it that way.
And then John.
And I also lean more into the oppose unless amended side. I just feel we need to send a strong message about this. Otherwise, all of the work that the board has been doing over the past few years is just going to be put aside. And I think sometimes we have to step up and take a strong stance on something. And, y'all have worked really, really hard on this for quite a while. And so I think for me, it would be oppose unless amended, and include this idea of the language we're starting to develop.
So are you making a motion, John?
If Roseanne can help me craft it, absolutely.
So the motion would be oppose unless amended, and then request carve out for boards that have already established license portability or temporary license process. Does that work?
Yes.
Yep.
I'll second that. Oh, somebody else say it?
I don't have another hand up. Does anybody want to second that? Or you sent, well, did you make the motion? Is the motion?
John moved
John.
and Leah will second.
Okay.
Kim?
Yeah, Sabina, does that language work for what we want to do?
Yeah, so you don't have the LEPs in your license portability, right?
Right.
So they would be the ones that would fall outside of that?
Ooh.
You would have to say license.
So they would be then falling within that, then you would have to do that for them.
So the only state that has an LEP license is Massachusetts, and their requirements are pretty similar to ours, but there's no California law and ethics. It's a master's or doctoral 60 credit hours, 2 hours supervised experience as a school psychologist, and passage of a national school psychology examination. I feel like that's more equivalent than the requirements for our other license types.
But then they wouldn't be doing law and ethics or the cultural diversity.
So perhaps I'll defer to Betty.
Well, I was just going to say that we have to, as everyone does, do law and ethics every time we renew. Does that help us out any?
Could. I mean, it's up to you. What you think, how the public would be protected.
No, because the law and ethics courses don't necessarily talk about California law specifically. It could just be the ethical codes.
So maybe the amendment that we're looking is just to carve out BBS.
It's going to depend on how you feel about allowing, you're letting LEPs out there and you're leaving them out there, hanging them out to dry with this language. So it depends how you feel about that.
From a regulator perspective, having 2 different applications for portability, that's going to be super ugly.
Is LEP coming? Are we going to do that?
I think we could look at it, but we didn't look at it at that time because there really wasn't another state that did it. That was the thing. Okay. But it's certainly something we could add them to it. Now that, I didn't realize Massachusetts did it, but now that we do.
Right, and so maybe the carve out is the board itself, since you guys do have license portability.
We could add, and for licensees to do, add California law and ethics requirement.
But doesn't it also waive the fingerprint?
No, it does not.
No, it said you had to.
If we request it, then they have to submit fingerprints.
Okay.
Yeah, it says if requested.
Okay, so there's that component. I guess.
I had another comment from John and Christina. I don't know if you want to let Christina was first.
I wonder, I was looking at Roseanne's number, of even the previous years. And it looks like, that encompasses, all the licenses. And I think the LEP population has always been very, very small. And so I kind of feel comfortable of, I think that's exactly the reason why, when we carved out the whole BBS, right? And that would take care of both issues. And so, but if that's not the direction that the board members want to go, then maybe, I would be comfortable. Yes, it's almost like, what really is the possibility, and how big, that is going to affect, the public. Yeah.
John, really quick, or John?
Something to say.
Sabina and Roseanne, quick question.
Yes.
If the language says boards that already have language carved out, or carve out boards that already have policies in place, that's including the board, not all the licenses that are under the board, correct?
Yeah, but that might also be a sticking point because they're going to say, well, you have it for 3 of your license types, but not one. I almost think it might be better to go back to our list of the differences and say basically we want the differences reconciled because the board
Right.
has determined.
You know, maybe they could refer, maybe the exception could be referring back to our Practice Act, you know, somehow incorporating those requirements in our Practice Act. Since we already have the language portability, I don't know how they're going to want to handle it. Are they going to want to handle it with a carve-out exception? Or are they going to want to handle it by referring back to our Practice Act, you know, or saying pursuant to, you know, whatever, Kim?
Yeah, I'm just going to just throw this out here. You know, we have our portability. If this goes through and we let it go through with the LEPs and, you know, being able to take advantage of it, the very first question I'm going to get is, why did they get, how come it's less for them and we have to do this from the other 3? And that puts me in an impossible position to explain. And it leaves me with that explanation that I really dislike providing. And that's how the law was written. And that's what started this whole portability thing anyway, because LPCC's had that comment. So, whatever, my recommendation is whatever we can do to convey that we have a portability bill. We don't want to be affected by this bill. I think that's what we need to recommend. Otherwise, it's a can of worms, and it's going to be really difficult for the board. Once you start doing the 2 different applications under the same roof, it's going to make it really, really hard for us. And I'm happy to include LEPs next ledge cycle if we want to do something for them.
Yeah.
So what are the Roberts rules for John being able to change his motion if he so chooses to do that?
Oh, because a motion was made and it was seconded, so.
Right, so he can accept an amendment, or he can ditch the whole thing and start over.
I am happy to remove my proposal, and I'd like to encourage us to recraft the language of it. So I'd like to recant my motion.
Now, do we have a motion? Leah.
I move that we oppose unless amend to remove the BBS from this bill. And of course, doing it with all the politeness and the language we discussed about how important we think it is, but that we already have a portability bill, and that our, not just our board, but our stakeholders as well, put 2 years into it and a lot of thought into it. And we also want to protect the licensees because if they don't have the right competencies, they could get in trouble. And then also, we don't want to harm any clients, consumers.
I want to second that.
Sorry, was that Christina?
Yes.
And I don't see any additional comments.
Okay. I'm taking the vote. Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Disposti?
Yes.
Susan Friedman?
Yes.
John Sobek? John Sobek?
Yes.
Okay, thank you. Wendy Strack?
Yes.
Christina Wong?
Yes.
Motion carries.
All right, moving on to SB 803. This bill is authored by Senator Bell, and its topic is peer support specialist certification. And this is a bill that the board has considered many times. This is just another version of it. So there's a lot of similarities to last year's version. So I'm going to go over just a little bit of the highlights. This bill required the State Department of Healthcare Services to establish a certification body for peer support specialists. It also requires the HCS, which is the Department of Healthcare Services, to amend the state's Medicaid plan to include these providers as a provider type with the Medi-Cal program. Originally, it was discussed about putting this this bill this year under our licensing board. We had some discussions with the author's office that it wasn't quite appropriate since we license master's level mental health professionals. So they have decided, at least for now, it looks like, to leave it in under DHCS's jurisdiction. And so under this bill, DHCS is required to define responsibilities, practice guidelines, and supervision standards for peer support specialists using best practice materials, and also to determine curriculum and core competencies. It requires the DHCS to also specify training requirements, a code of ethics, and it provides minimum requirements for applications for certification. The bill also provides that this act does not imply that a certification holder is qualified or authorized to diagnose an illness, prescribe medication, or provide clinical services. It does not alter the scope of practice for a healthcare professional or authorize delivery of healthcare services in a setting or manner not authorized under the Business and Professions or Health and Safety Code. The bill requires that DHCS adopt regulations, basically specifying the credentialing process by January 1st, 2022. So, like previous years, the author has noted there's a need for a peer support specialist certification program, and that California lags behind the rest of the nation. A lot of other states and the Veterans Affairs Department already have peer support specialist certification programs. And we've, in your memo, you'll see some examples of other states and what they already require. A little bit of information about past board feedback, because we've considered a similar bill to this pretty much every year for the past few years now. So last year, well, let me point out past board feedback. The bill appears to outline a scope of practice for peer support specialists. It's somewhat indirect. I point out that you may wish to review and discuss section 14045.15, which talks about the article does not imply that an individual who's certified to authorize or is not authorized or qualified to diagnose an illness, prescribe medication, or provide clinical services, and it also does not alter the scope of practice for healthcare professionals. So there's that language there. For similar bills in the past, the board has at times recommended more direct language in order to protect its practice acts. So I included some language there that we've asked for in the past. However, the author's office has not been extremely responsive to adding in that language. I think that they feel that the above language in 14045.15 is sufficient. And looking at it, I feel that does cover us as well. I'd let Sabina weigh in if you had questions, but I'm guessing they probably don't want to have to specify this for every type of medical professional that there is, which is why they're using more general language. Other past comments on this bill from the board, last year the board had wanted identification of supervisors. The current version of this bill requires DHCS to define supervision standards for peer support specialists. The board might want to discuss if that's sufficient. The last version of this bill last year did not discuss supervision requirements at all. And the board requested they be specifically, our license types be specifically included. The bill also does not, and past versions of this bill have not specified fingerprinting requirements to obtain certification. This has been a concern of the board in past years. However, last year the board decided not to request its inclusion. The author's office in discussions had indicated that they prefer not to, because they prefer to leave that to DHCS in regulations to determine what they want to say in the regulations about fingerprinting. And so I think I'm going to kind of leave it at that. I've noted some of our positions last year, and the past 2 years versions of this bill have been vetoed. Last year, the governor kind of alluded to budget concerns that it should be considered in the budget process. So I don't know what's going to happen with this bill moving forward, although I do know that the author is very strongly trying to move this bill forward currently. So we can go ahead and have the board discuss.
Okay, Christina Wong.
So I just, I think every time when this bill come up, I show a pretty strong support position because, working in the field and directly with, these peer support people, I think the direction of the bill is definitely, accurate, and we're really slacking behind. And I think it provides definitely a way not just about assuring the quality of these peer support people, but also provide another ladder for them to to continue on their employment professional path. I so I think they're definitely continuous to have that discussion about some of those loopholes and that the flaws of the bill, but I would love to just put in the record that I am fully supported and I'm representing my peers for the peer support people that they love that too. So I'll leave it at that.
Yeah.
I'm leaning toward a supportive amended. I'm nervous about the supervisor situation because there could be situations where there's no mental health professional working in the environment. And if there's no mental health professional there, then they wouldn't know when to refer people out. They don't have anyone to talk to. So I appreciate that they're leaving that to the DHCS or whatever the acronym is, but I'm nervous that that it won't be under a mental health professional, a licensed mental health professional.
And then Crystal?
I just want to say I fully support peer specialists. I feel like they are credible messengers and they are a best practice when you look at research and when you look at treatment purposes. And so they work really great alongside therapists who oftentimes have a different level of boundaries and legalities that we have to go by. And peer support specialists, really, that's not their role. It's like very different. And just speaking from perspective of having worked inside of a county that started implementing peer support specialists, but called them something different. They often fell under the category, like they would get supervised under, not the therapist, but like a supervisor or program manager. And so I think that oftentimes is to the discretion of the agency of who would then supervise them, because it's not always like a clinical person that has to supervise them. Sometimes it's like a programmatic person that's supervising them because their like role isn't clinical. It's like more of like case management and like walking through life with people and things like that. So anyways, I support this.
Okay, we have a comment from Max, and then Susan after Max.
Likewise, I support that. I do understand why Leah has a little bit shared that concern. Believe it or not, I think actually with the situation that we are living through in terms of having a supervision closer, with the virtual experience that now we're all adopting in one way or another. I've seen in my particular agency, for instance, in a few cases where this case management turned more into a clinical work, because sometimes cases you can't just define them, right? There are overlapping. We were able to reach out to the supervision and to the mental health providers that right away that had opportunity to intervene if it was necessary. So I feel like a lot of agencies now are having more flexibility to do that. So perhaps I hope that might reduce a little bit of your concerns, Leah, because I know you're on the right side of this, but that's how I felt a little bit. It kind of helped me on that part.
Susan? Oh, there you go.
I strongly support this bill. And I think with the extent of the homeless situation that we all are part of right now, this is really, really important. And these people can be extraordinarily helpful in that situation.
Okay, I do have public comment. Does any board member want to make additional comments? We'll go to public then. Rebecca.
Hi, Becca Gonzalez, NASW. Just wanted to make it clear that we are in full support of this bill. we see the use of peer support under the purview and the vision of the Mental Health Services Act.
And we have John.
Just curious, because I was not present when the other two bills were put through. What is the leaning away from a fingerprint requirement?
My understanding from, I'm trying to remember my past discussions with them, is that they don't, there might be certain peer support specialists that do have a criminal background, so they might get a hit on the fingerprints, and they don't, want to come down too hard on that. They kind of want to leave a little bit more discretion to the DHCS in their regulations rather than putting it in the bill, is my understanding.
I don't see any other comments. So.
We have a motion?
Can I make a motion?
Yep.
Okay, Christina.
I would like to make a motion to support the bill.
I second that motion.
Okay.
Okay, ready for a vote?
I don't see any comments, so.
Okay. Oh, Leah has.
Oh, Leah, yeah, sorry.
Just before I vote, I just want to make a statement for the record that I have seen some agencies that are extremely poorly run, and that's why the supervision thing was so important to me. So I just want to state that, and that's good. That's it. I don't need further discussion.
Mm-hmm.
Okay, I'll proceed with the vote. Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Disposti?
Yes.
Susan Friedman?
Yes.
John Sobek?
Yes.
Wendy Strack?
Yes.
Christina Wong?
Yes.
Motion carries.
All right.
All right, moving on to SB 855. This bill pertains to health care coverage, mental health, or substance abuse disorders, and the author is Senator Weiner. This bill expands California's 1999 Mental Health Parity Act. That act required health plans and insurers to provide coverage for the diagnosis and medically necessary treatment of severe mental illness for persons of any age, and for serious emotional disturbances of a child under the same terms and conditions applied to other medical conditions. This bill would instead update the 1999 Mental Health Parity Act and require health care plans and insurers to cover all medically necessary treatment of mental health and substance use disorders under the same terms and conditions applied to other medical conditions. So current law, the current Mental Health Parity Act that's in place defines severe mental illness, and it's very specific. You have to have a certain diagnosis. There's like 9 different listed diagnoses you have to fall under that. It also has a very specific definition of serious emotional disturbances of a child. So this bill broadens that. It provides a definition of mental health and substance use disorders. It has to be a disorder that follows under any of the diagnostic categories listed in the most recent edition of the World Health Organization's internal statistical classification of diseases and related health problems, or listed in the most recent version of the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Health Disorders. It also provides a definition of medically necessary treatment of a mental health or substance use disorder, and it defines a healthcare provider, and healthcare provider gets pretty specific to our licensees. It includes a person licensed under Division 2 of the Business and Professions Code. That includes our LMFTs, basically our licensees and associates. Then it also goes out to call out specifically an associate marriage and family therapist or marriage and family therapist trainee, or a qualified autism service provider or professional. And likely the reason it calls out AMFT, the law, there's a Business and Professions Code, section 23.7, that basically says license equals license or registration. But sometimes the associations prefer to have it specify our associates because people don't remember that particular code says a license equals a license or registration. That's why you're likely seeing that for the AMFTs. Trainees is a bit more of a question because we don't license or register trainees. They might not fall under that definition, which is why they're sometimes specifically included. The bill also requires health plans and disability insurers that provide hospitalization or medical surgical coverage to base medical necessity determinations or utilization review criteria on current generally accepted standards of medical and behavioral healthcare practice. And that's specifically defined in the bill as evidence-based and must be generally accepted by healthcare providers practicing in relevant clinical specialties. And it goes on to give some specific examples of that. So that's what the bill does. The author's intent is to update the 1999 Parity Act. They state that California should require insurers to cover all medically necessary mental health and addiction treatment. It is unacceptable that insured individuals cannot access the health services they desperately need. They state currently California only requires commercial health plans to cover all medically necessary treatment for a limited number of mental health, but no substance use disorders. They also note that additionally, coverage for mental health and substance use services should be required to evaluate medical necessity using criteria that are fully consistent with generally accepted standards of mental health and addiction care. So that's the author's statement. One thing to note about this bill, as I pointed out, in the definition of a healthcare provider, the bill specifically calls out associate marriage and family therapists and trainees as being included in the definition. We always like to, if one of our associate types is called out, we start to get a little uncomfortable when not all of them are called out specifically, because even though we have Business and Professions Code 23.7, which technically covers registrants, it creates some inconsistency and questions about whether they're included in the definition if they're not specifically listed there when one associate type is. So I would ask the board to discuss if we want to include also ASWs, social work interns, associate professional clinical counselors, and clinical counselor trainees in the definition. I know that NASW has some concerns about calling out social interns, so I'll let Rebecca or Jan Lee speak to that. But otherwise, I'll open it up for discussion.
Sorry, Leah.
So I'm really in support of this. Just with regard to the trainee conversation, right now trainees aren't covered for other stuff anyway. So it seems weird to me that they added MFT trainees for this, because MFT trainees can't get covered for other issues. Usually it has to go under the supervisor's license. So I'm interested to hear what others say, but I don't know that trainees should be able to sign off on insurance stuff at all, but I can be persuaded otherwise.
Max? Volume or mute. Sorry.
To my defense, that was my first time today. But anyway.
We'll keep tabs.
Now they were almost. No, I'm fully support. It's not the medical for bill all that I would like to see. I'm sorry that I would like to say that, because obviously we have to navigate around insurance needs and requirements, and it would be nice not to have to deal with that and have guarantee more free access to it. But in lack of that, I'm definitely in support with the bill, and I think it's a great progress for California as well. Thank you.
And John?
So I have a curiosity about the specific use of evidence-based practices. We have been finding with insurance in the past that this has a huge effect on the amount of sessions that they will approve for, and it creates a lot of barriers to care in some places. So I'd just be curious if anybody has any thoughts about the specific use of evidence-based practices, and if it's anything we might want to shape a little bit.
So I have a public comment. Is that okay to go to? Nod heads. Everyone fine? Okay. Rebecca?
Becca Gonzalez, NASW. I was just going to respond to the specific inclusion of ASWs and social work interns. We do want our ASWs included, but as I stated on the other bill, we don't like to put social work interns into the code as we want to keep control over our education.
And Jen? Alan?
This is Jennifer with CAMPT. I wanted to respond to the question or the comment about the reference to the board. We had extensive conversations in our legislative committee and then with the authors and sponsors about the references made in the bill for best practices. And the sponsors explained to us the rationale for that was that health plans have been drafting their own medical necessity language that sometimes would conflict. And so they wanted to kind of limit what a health plan could specify and really rely on best practices for determining the length of stay on the clinical approach. So, you know, if the length of stay, for example, for a certain condition was 2 weeks or treatment was for 6 months, with these caveats that the health plan would have to honor those when making their some of their determinations. And as for the inclusion for us, you know, I asked them, did the initial references and before the bill was amended include our associates? And they didn't say yes or no, and then the bill was amended to include us. So that wasn't a specific ask that we made. It was just one of those things that they did based on our conversation. They've been very open to questions and making changes throughout the process. They've been very good to work with.
Okay, Leah?
Jennifer, what do you think about trainees? Are you comfortable with trainees being part of this bill, even though they're not going to be part of other types of mental health treatment?
You know, I would defer to your expertise. There was some questions about trainees being included once that amendment went in. I didn't get a firm yes or no, they should or shouldn't be from my association. But it did kind of raise some eyebrows. I'm happy to look into that more. Not being an expert, you know, still relatively new to CAMPT, not knowing a lot of the background, I don't feel comfortable answering that question specifically. Sorry.
And then Betty.
So I just, I agree with Leah on the trainee issue. I have concerns about having language that says trainees. And then I also just wanted to note that if we do, when we make a motion, that we include our other associates in that language. So just those two comments.
And Leah?
So Betty, you can make that motion.
I would be happy to. Are we ready to entertain a motion?
I think it looks like there's comments that are slowed down.
Okay, then I would offer a motion that we support the bill with the amendments as noted to exclude trainees and include the other license types, including the associates. Did I miss something there that I need, Roseanne?
Nope, this motion, we support the bill and then separately ask them to exclude the trainees and then include ASWs and APCCs.
I'll second that.
Christina, second. Okay, I don't see any further hands raised.
Okay. Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Eddie Conley?
Yes.
Max Disposti,
Yes.
Susan Friedman,
Yes.
John Sovek,
Yes.
Wendy Strack,
Yes.
and Christina Wong.
Yes.
Motion carries.
All right. SB 878 by Senator Jones. This has to do with DCA applications and wait times. This bill would require the board, as well as other DCA boards, to post on its website the current processing timeframes for initial license issuance and license renewal applications, as well as average processing timeframes for each license category. The author states that it's crucial for DCA licensing entities to process applications in a timely manner so businesses can open. They know that some boards provide applicants with average processing times, but not all of them. As we've kind of discussed earlier at the beginning of the meeting, our board currently posts processing times by application type weekly. We post that on Facebook and Twitter, our social media. It's typically easier to post it on there, and we believe it has a larger audience. We can post it more quickly than we can on the website. We don't post based on average processing timelines. We've had more success with posting based on date received, because we basically say, okay, we're now processing applications this week received in the date range of, let's just say, February 1st through 5th. And applicants know when they sent their application, so they know when we're going to get to them easier that way. We say an average of 20 days, that kind of leaves a little bit more questions, or leaves a little bit more room for questions. So we've found specifically for our board that the date received has been successful for us with our licensees. So some suggested amendments. Staff had a few concerns when looking at this bill. A couple of recommendations, possibly the board might want to discuss an amendment, and asking for an amendment with an option for the posting to be on social media instead of the website, and so social media can be updated more rapidly than the website. An allowance to post applications being worked on based on receipt date rather than average timeframes. And then a specification of how often processing timeframes must be updated. Our processing timeframes are always changing. We right now post them once a week, and that's been pretty successful for us, but it's a little unclear what the intent of the bill is on the frequency. And then clarification of what is meant by an initial application. The board has several applications throughout its licensing process. There's several steps. You have associate, you have exam, you have initial licensure. Right now we post everything. We would probably continue to do that, but there's not really, the board refers to an initial application, and that's kind of, doesn't really mean anything to us in relation to what we have. So that's what I have to say about this bill.
And Leah, let me open it up. Hold on here. And Leah?
So I'm going to go crazy and take a risk here and make a motion, because we can always discuss after, to support, if amended, with the recommendations that we have listed in number 3 as suggested amendments. The question I have for you, Roseanne, before I close out my motion is the number 4 bullet, the clarification of initial application. Is that something that you just would work with them on? Because I don't want to make that feel like criteria, but you could help them craft better language.
Yeah, so you want to require the first 3 bullets and then just work with them on the third?
Yeah, on that 4th
totally.
one.
We can definitely do that.
Okay.
I'll second that.
And I do have John as a comment.
One thing, Roseanne, that might help do a little bit of specificity is when we're talking about social media, actually language it that it is either board monitored or board facilitated, because otherwise the feeling might be like, so everybody's just putting it on their social media accounts. And I think specifying that language would actually make it more likely that they would say like, oh, the BBS has a Facebook page, they're posting it, yes, let's go with it, versus Kim was putting it out on her Facebook page.
You want to say board, official board moderated, so
board monitored or facilitated.
Board facilitated. I like that word. What do you guys think?
Well, I think if the board is posting, I mean, it is going to be by, I mean, if we're posting it, it's going to be by the by the board. But I mean, if you're going to be, yeah, maybe board official
website.
Yeah, official. Although you don't want to, I'm not sure about the word facilitated, because that sounds like you're just running like a discussion, or you're just kind of there facilitating. I'm not sure.
I think board official webs. I'm sorry.
Sites, just sites, board official sites.
Or official board.
Official board.
Official
social media.
Board social media.
Yeah. That's what official, board social media sites.
The keyword is official, right?
So do I need to amend my motion, or are we good with that?
Defer to the attorney.
Yeah. You're okay with it, because all that language is going to be up to Roseanne in the end anyway for the letter.
So basically the first bullet would say, an allowance for the posting to be on official board social media instead of the website.
Right.
Okay. I do not see any comments or any additional comments.
Okay, here's the vote. Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Disposti?
Yes.
Susan Friedman?
Yes.
John Sovek?
Yes.
Wendy Strack?
Yes.
Christina Wong?
Yes.
Motion carries.
And we have a unanimous vote for a break. I don't know, Betty, if that's
We're
you would
getting
entertain.
close. I think we're getting close, but hang on. Hang it. Okay, there we are. Okay, yes, absolutely. What are we thinking? We're getting really close to the end here.
5 minutes, it
just
looks like.
Let's do a quick 5-minute bathroom break and come back. We should be able to finish this up in not too much longer. So absolutely 5 minutes. Thanks, everyone.
Okay.
Dan.
Yes. That is SB 1168. The author is Senator Morell, and this has to do with state agencies and licensing services. So this bill does two things. It requires the board to establish a process for a person to defer fees required to obtain a license, renew or activate a license, or replace a display license if the person is experiencing an economic hardship as a result of a state or federal emergency caused by a virus. And then second, this bill would also require the board to establish a process to expedite licensing services for a person who has been displaced by or is experiencing economic hardship directly due to a state or federal emergency. So under existing law, there are 3 different types of state emergencies that can happen. Those are defined in the memo that you have there. And current law that came into effect last year allows state agencies that issue licenses to establish a process to reduce or waive fees for licensure renewal or activation, or license replacement for individuals experiencing displacement or economic hardship as a result of a state of emergency. And so the board will likely in the future be considering that as regulations. However, as you know, our regulation process has been very slow, so we're a little backed up on regulations. That is on the list. The author notes that in recent years, California has experienced several costly natural disasters, including the Tubbs Fire, the Camp Fire, the Southern California mudslides. Some of those are the examples. They note that many of these individuals have had to replace licensing documents and have had their businesses lost or destroyed. So they're seeking to help relieve pressure on these individuals and help them get back on their feet. A couple of points of discussion. The law already authorizes the board to establish a procedure to reduce or waive fees for licensure for individuals as a result of a state or federal emergency. This bill would take a step forward and require it for economic hardship when the emergency is due to a virus. Creation of a process would be feasible through the establishment of regulations. However, the board might wish to discuss whether an emergency due to a virus is the only type of emergency where a fee deferral would be appropriate. It seems like there's other different types of emergency. A virus is obviously what we're experiencing right now, but it seems like there's other types of emergencies where it could be just as important. In terms of the feasibility of the part that requires us to expedite licenses, the board already, as we discussed earlier today, expedites licenses under certain situations for honorably discharged military veterans and their spouses. And for relatively small scale declared emergencies such as the Tubbs fire and the Camp fire, expediting licenses would be feasible to implement. We can do that. And we would need to develop a way to flag these applications as ones to expedite. It's a little bit more unclear how feasible the expedite process would be for a larger scale emergency, such as one that we're currently experiencing with COVID-19. The emergency affects virtually all of our licensees and applicants, and the board has a limited number of staff, so it would be nice to expedite everyone. If we're expediting everyone, it's without more staff, that's going to be difficult. Because our staff is already working to process as many applications as they can. If the board were to get permission to hire new staff, that might not have much effect in the short term because it does take time to hire and train new staff. So those are just a couple of points for consideration. If the bill were to pass, the board would need to run regulations to establish the fee deferral process and the expedited license process, and establish criteria for identifying individuals displaced by or experiencing economic hardship would be eligible. So we can go ahead and start the discussion on this.
Okay, Leah.
So the irony of this is our income to run the board is based on those fees. And, we're going to talk about or get a report on the fee increases that we've made or that we've requested. I like philosophically, I love this idea to waive or postpone. But if those people who, like, let's say the predictions that 20% of the people will be unemployed or be experiencing pretty severe economic hardship, then that means we get 20% less fees, which means we don't have a way to pay for the increased staff in order to be able to even maintain what we're doing, much less step it up. So that's just kind of in my foreground. I really like this idea, but I don't know if we can.
Roseanne, just a quick clarification for myself. Is this having to do with replacement of licenses?
That's one of the things that it allows, but it's also for renewal or activation if it's the emergency is caused by a virus. It says defer fees to obtain a license, renew or activate a license, or replace a physical license. So it covers much more than just the replacement documents.
Okay. Kim, had your hand up?
So historically, we have waived, fees to get a duplicate licenses for the fires and such. And then in some of the waivers that came out, there was a fee waiver to hurry up and, get the inactive retired folks back in the game and just kind of move forward with that. I do have strong concerns that if we were to apply this to all of California licensees and associates, if we're waiving it for everybody in that renewal cycle, that's going to dramatically impact our funding source. I think it's reasonable. I'm with Leah. I like the intent, but I just, from a practical implementing it, it's going to be really tough. going to be really, really tough.
John?
So I think one of the things, Kim, that you just pointed out, though, is that if we're expediting everyone, then actually no one's getting expedited. Because if you're doing it for the entire licensed population, then you actually are not changing the speed that anything can happen at. The other piece of this puzzle, too, is does the existing legislation give us enough coverage to be able to apply this to people without actually having to have a virus carve out? I'm just curious about, are there things that are missing in the existing legislation that says this virus carve out is going to make something more powerful happen?
John, I don't really think so, honestly. Because when the campfire happened, oh God, what was that, a year ago? We had people that had everything burned. So they didn't have their hard copy license, they had nothing. And once they started asking for waivers or to waive the fees, we were able to do that. And what we did was, hey, we verified their address and then there was a site map. I mean, so we can do those kinds of things now, but the virus seems, I think this is going to be overwhelming because this would apply to all of us at DCA. So the medical board would lose income. We're going to lose income. Everybody loses income. So from a practical standpoint, yeah, it's, I don't know.
And it's kind of tough with the pandemic type of virus thing. How do you determine the loss? I mean, you would have to get the medical. I mean, I don't know how to differentiate between. It would be that would be a tough call. Max?
Well, my thing is that in circumstances like we are experiencing right now, COVID in particular, lots of jobs, and then situations of emergency. In general, I mean, with COVID, because it's been such a nationwide emergency, but with situation like, let's say, a fire that hits a particular region, well, let's say several hundreds of which will be but let's say several hundreds of our licensees are struggling with that, so we'll have to reapply and we have to waive the fees. Those are situations of a state emergency where at a certain point we know that the BBS has funding to provide services. We just can't predict that to a degree because it depends on the number, the circumstances, how often it happens. Overall, I really think it's a good bill. I think it goes in the sense of the directions that this board has assumed since day one, make sure that we don't create more barriers when people are struggling. And that, yes, it will present a problem, because that's obviously where the funding comes from. But at the same time, that will be also soliciting our legislator to pay attention to the fact that if there is no money, we had to shut down the service that we provide for our own licensee as well. So it's kind of like a take a given. I think the bill cannot address the detail of those circumstances to in a way that could cover every single challenge. It's just really hard to do that. Nobody will have ever expected what's happening right now, right? In a way that how Dippin has affected us. So I support the bill, but I definitely that's a concern, but it's not something we can resolve here, in my opinion.
Betty? Unmute. Sorry.
Boy, oh boy. I must be getting tired because I'm getting worse at this instead of better. This is another one that I'm really concerned about because from an optics standpoint, from a caring standpoint, from who we are as a board, we absolutely want to support people when they're in, suffering economic challenges. I mean, how can we not? On the other hand, we're almost fully funded by our fees. And if we stop charging fees or defer fees, I mean, it's like, I don't know. We won't be able to continue to support the good work that people are doing out there. And So that's just my thought on it. I think we're caught between a rock and a hard place. Yes, Kim.
So some of the things that would happen if half our registrants renew every year. The licensees renew every other year. So in any given year, we have half of our population renewing, which is that's how we get through life. When we don't get enough revenue to support our activities, some of the things that we have to stop doing immediately is AG referral, because I don't have the money to pay the Attorney General's office for the hours that were billed. So then we start slipping down into our public protection mandate. Exam workshops, travel, that's expensive. So we're gonna have to find ways to cut there. And then in general operating expenses, I mean, so it's like your own household budget. You're getting the reduction in your wages, and you're gonna have to find places to cut. And historically, as I said, the first thing that goes, it's the AG referrals. So you hold those cases until you get more funding after July 1, and then you rush them all over. So we're delaying, our consumer protection mandates, which I think it's concerning. And I agree, it's terrible not to support people, but I think historically where we've been able to make waivers and waive those fees, we've been responsive to those events. And in doing that, it has not adversely affected our revenue stream.
And then I have a comment from Deborah.
I have a couple of questions. I know that when people are on probation and they can't pay for a lot of the fees and such that we have, there seems to be some type of a program that those people can apply to, and they get some of those fees reduced or waived. I'm talking about the fees on probation. Is there a particular formula? Is there something that they have to submit to show that they are unable to make those kinds of payments?
That occurs during the negotiation. It's very common because the probationers are required to pay the fees for the cost of probation. So what happens is you're negotiating all that stuff. That could be a give and take section. There's no formula to it. It's sort of, and we get the letters that say they can't afford it, but it's one area where we can give because we know the cost of probation is so high, but that's the only area. Otherwise, they're paying whatever they're charged for the fluid testing. They're paying whatever it costs them to have the therapy and the classes. So it's only investigation costs.
So so thank you for that answer. And my follow-up question is, would it be too complicated to implement a program that would take into consideration those people that may have lost their jobs, that maybe are on unemployment? That would be easy to show. So that maybe there would be kind of a give and take. Because not everybody needs to have their fees waived or reduced, but there may be some that actually do. And I don't know if there would be an opportunity for us, or would it be too complicated?
No, it wouldn't be. It would be what we would run in regulations and specify in the regulations.
Oh, okay.
And so that's how, so this would go into effect as a statute. And then to further define it, we would run regulations, much like we did with our fees. They're set in statute. And then if we want to get down to, more detailed or granular level, then you run the regulations. So we can certainly do that. That would probably be the best way to handle it, Deborah, honestly, because you could be supportive, but then we would have some criteria. But the criteria is in regs.
Okay. Well, thank you for that.
You're welcome.
Okay, Christina.
So, being directly impacted by the campfire a couple years ago, and I have a firsthand experience, how hard it is, for the licensees and the registrants. However, what we're talking about, that whole, that requirement of the fees, it's kind of like the artery, of the board's revenues. So I am wondering, if actually as a counter proposal, whether it's possible, to say, instead of like any fees relating to license, whether it actually can, talk about like, waiving some of the continuing education units, for example, because those are the things that, that would actually cost a good amount of money, for the, renewals. So, I mean, I'm not saying that, that I'm sitting on right there just for the CEU, but really is exploring the other ways to support the pandemic, and yet not really compromising the survival, or the viability, of the board.
Wendy?
I was gonna actually suggest something along the lines of what Deborah said about having some sort of process that demonstrates that there's an impact, because like some folks said, maybe not everybody's impacted the same, and so we might need to treat people the same. But I think it's important, as the board has before, to find ways to help people through a crisis and through an emergency. But not everybody needs the same relief, and so there's got to be some give and take here about how something like this could move forward in a permissive way that doesn't cripple the board's finances.
And Leah?
Max could go ahead of me.
Okay, Max?
I just want to, I mean, in all of this, once again, it's just like, if there is a state of emergency, if there is a calamity, disaster, the state comes in to supply what's needed in that disaster. So we're a state agency. So if all of a sudden our budget goes down because the licensee are not able to pay, my assumption, I know the politics of that is more complicated, so I'm not trying to simplify. The state will have the responsibility to supply a vital service. We're not just an agency that can go away because we don't have the resources to supply. So it's kind of like a conversation in a vacuum for what I see in regards to having a situations where all of a sudden the quantity of money coming through will compromise our services to a point that, so it's not like just our problem, right? We're part of the DCA. Is run by the state of California. So this is not something that is completely, up to us as a board. We need to provide those resources. And then in situations of natural disaster, usually the state of California steps in to provide those agencies the relief they need, usually, but it's not automatically. I understand the politics around it, but I don't feel like that could be an issue at the moment.
Kim?
In response to that, Max, that's why we have our business continuity plan. That's how we respond to keep the services going. But if we're underfunded, then we're going to have to find the funds somewhere else. And my experience in the past is that when boards have run short, or they could be running short of funding, sometimes there is a loan that is made to the agency that you would be repaying. So.
Can I go?
Yeah.
So, and also in response to that, maybe some of you don't know, in 2008, the state borrowed money from us because we were flush at the time, not our situation today, but we had lots of money, and we just got paid back last year, and that was in 2008. So when I look at this situation, it's way worse than 2008. We're already looking at a projected $54 billion deficit in the state. We're already looking at a 10% loss for the CSU, for the state employees. So I with all those losses, it isn't feasible to set a policy this broad. And with regard to people who lose their jobs and they're collecting unemployment, then what they can do is put their license on pause while they're not practicing, because if they're unemployed, they're not practicing. And then once they're ready to practice, they can turn their license back on again, right? Am I correct, Kim? Like there's a method?
Yeah. Well, at the renewal, they can renew inactive, which is half the licensing fee. And then, and they can keep renewing that way until perpetuity every 2 years. But if they want to practice again, then they have to pay the balance of the fees to reactivate it and attest that they've completed the DEUs.
Yeah, so they would be able to do that once they're employed to try to, get back in the system again. It's just, we can't rely on the government, the state government in this case to make us flush. There is no money. And who knows what the federal government is going to do. There's just no money. And we can't run without being able to pay the AG's office or cutting in lots of areas. I mean, and what will happen is that it'll take 6 months, like it did before, in order for a license to get approved, someone to get approved to take a test for the license, or 6 months for an associate to get their associate's number in some cases, on especially in May when it's really bad. So what this does is it slows down everybody else who's still practicing.
Sorry, comment from Betty?
Yeah, yes. My question is the language on this, it says would require the board. So is this or is this proposal specific to the BBS? It doesn't say all DCA boards, it says the board.
No, it's any state agency that issues licenses.
Okay. So then my next question, okay, I see. Okay, so
in context of our discussion, it requires us to do it, but it requires other state agencies
to do it too. So obviously other state agencies are going to have similar situations to ours. Do we have the option of just opposing this?
You can. I mean, all of the positions are on the table. You could oppose. You can be opposed unless amended. You can be neutral.
Well, I, as I said before, I'm sympathetic, understand the situation, horrific, but we have been saying all along that what we do is incredibly valuable to consumers. Our licensees need to have their licenses renewed, and I mean, we provide a critical service. That's clearly, we provide a crucial service that we're not going to be able to provide if we can't charge fees. So I don't see how we could even, and I know I'm maybe getting ahead of myself, but I don't even see how we could be neutral on this, because that says kind of like, well, it's not going to impact us. Go ahead and do what you want. It's going to have a huge impact on our ability to serve the public and our ability to function in general. So certainly, I know we have some more comments and we have the public comment, but it would be almost a death sentence to be able to say, well, because realistically, the monitoring of this, of who's impacted and who's not impacted, there are going to be a tremendous number of people impacted that are going to be able to demonstrate some impact. And whether it's a complete loss of income or whether it's a partial loss, whether it's loss of house, I mean, there's going to be impact that's so across the board that I can't see how it would not have a huge impact on our agency. And we're not talking a few isolated cases. If it was a case by case where we could look at a few isolated emergencies, yeah, this is not that. This is across the board. So
I'd also add to that it goes for the other side of the bill as well, and that we're not going to be able to expedite everybody either. It's just not. It's a nice idea, but if it's a statewide emergency, staff is not going to be able to expedite it, which is it just, as much as we'd like for that, it's not feasible.
Okay, we have Deborah.
I just wanted to follow up with what Max said, and that is, that we're going to all be in the same boat, and that the state should, you would think, would want to support itself. And I think that we would find ourselves in the same position that the schools are looking at, which is they're offering them MOUs, memorandum of understanding, and what comes with that is interest. And so even though we would have to, they would offer a loan, which they probably would, we would end up, it's just like a credit card. We wouldn't have the ability to pay off the principal, and at the same time, the interest is building to make that payment at the end of the day back to the state government. I don't know that we could, because we don't have that surplus of funds like we used to actually help even pay down the capital. And at the same time, all that interest, like a student loan, and all of that interest is just building and building, and who knows how long it's going to take to get back out of this. It's just that I don't know that, I guess I don't have the faith you have. I think that they would probably come through, but they would come through with a loan, and there would be a lot of ties to getting that money. So anyway, I'm really mixed on this, because we're a caring license, and so I just don't see a one shoe fits all. That's not the case with 100 and something thousand licensees they're not all hurting. And I don't think they all need some type of assistance, but some do. Okay.
Crystal?
Hi, I have a question. Could we oppose or in some way just like say that the BBS doesn't want to be a part of, considered as one of the boards that's being looked at? I just feel like this is how I see it. There are certain boards where I can see why this legislation came about, because there are some professions that were profoundly impacted because of COVID and because of the pandemic. Like they can't work even still, or whatever it may be. But I feel like we've talked about this a lot, where we are an essential need. And I feel like our profession people were impacted, but people are not completely impacted on the state. There's organizations still running because their funding comes from different sources. They can do telehealth. They have other ways of actually providing their service and still paying their employees. And so they're actually still working, whether it's through a state agency or county agency, a nonprofit, or whatever it may be. And of course, I'm not speaking for every single person, because I think it impacted private practice in a different way. But when I'm looking at where our profession, most people within our profession, where they are rooted, it's through agencies and organizations that are funded differently, where they're still providing services. And so I also look at, the fees, and this question came about in previous board meetings where the fees, just how they were going to be going up, all those different things. Our fees are relatively low, and they're not very high. And I'm not in agreement that we should be putting ourselves in a position where we're actually going to be hurting our people throughout the board, through everybody's going to be hurting more than benefiting. And so how much are we really protecting our public if we're not really functioning at full board capacity, if we don't oppose something like this? So I'm going ahead of it, but I'm just saying, I'm in a opposition of something like this going into effect.
So are you making an oppose unless amended to remove the BBS because we don't have the fund condition in order to support this?
Yes.
Well, if I may, I think if we're going to oppose unless amended, I think we also point out that the current law allows us to waive some fees. I don't know, Roseanne, I don't know if you know, do we have any idea what the fiscal impact would be to this if it were to take effect?
Really, no.
There's not really a way to estimate a fiscal impact because there's all different types of emergencies, and
Right.
I mean, there's no way to know how many people will be qualified as affected. So I mean, it could be everybody, or it could be 10 people.
And then what they need, is it they need to get a renewal, or is it just a search?
Right.
I mean, it's all over the place. You can't really.
Well, just some really rough math. When you have let's say for round numbers, 60,000 renewing, just on the renewals, if that applied to everybody, we just lost 50% of our income. And I'm looking at not this fiscal year, but the following fiscal year, we're already going to have to reduce by 5%. And so, then if this were to take effect and everybody took advantage of it, we're losing 55% of our income. Essentially, we would stop AG referrals, I would say probably in about month 4, month 5 of that fiscal year. And so it's scary. I mean, I'm empathetic, I get it, but the bill does not come with any criteria. It's just sort of a blanket coverage. And without the criteria, which we would do through regulation, which quite frankly, we're at bare minimum a year and a half from implementing. And by then, COVID could be done. So.
And even if the regulation, that's so hard for us to have to be able to interpret, we would have to have a whole unit just going through applications to determine whether they fit these various, I mean, I don't know what we would even put into regulation as to all the different variables that could happen.
Yeah.
I mean, and I think what we would proceed on is kind of like what we're doing right now. If we see something coming up, we would jump on it to get waivers or something to deal with the bigger situation and go that way instead of, this way.
So Kim, were you not okay with Crystal's motion?
I'm fine with it. When we respond in our comments, I think it's important that in our letter we point out that existing, we're concerned about the fiscal impact, but we're also, where we've been proactive in this, but the law already allows us to do some of this stuff that they want us to do.
So just adding it to the motion. I'll second that motion then.
Okay.
So can we say that again? So it'd be opposed unless amended. Go ahead.
To remove the BBS.
Okay.
And then Kim can help with, because of our kind of fiscal condition at the moment, along with already having something in place to allow for assisting people under exceptional circumstances.
And just my last comment, this is just a comment, and then I know there's more hands. I was just going to say, I feel like the BBS, the board has done a really great job at releasing these really great waivers that I feel like those are the actual things that people are feeling stressed about. It's like taking their tests or, paying for things getting extended for them to be able to do, to sign up and then complete their CEUs and be given more time, more of a grace period. I think those are the bigger things, but that was just my last comment.
Okay. We do have quite a few comments. We do have a public comment that has been very patient. I don't know if we want to, what do we want to go to right now? So there's still board comments. Should we go to those first? Board member comments? Kim, what do you think?
Yeah, I think so. Let's let the board finish commenting.
Okay. So I'm going to start with Christina.
It really sounds to me that it's a straight oppose. Because what we talked about, all this concern, it's not just specified, specifically applied to the board. It's actually across every single board that especially that fiscal impact. And so I'm thinking that when I know that we have a better mechanism to do fee waiver and stuff, but I think eventually it really is about survival. And so I would, and I'm thinking that, maybe a straight oppose, will actually carry a stronger message, to have, to let the author of the bill know that this is really not viable. and this is not implementable, not just for us, but for all the boards. So that's just my 2 cents.
Okay, John.
So one of the things that I might consider adding to our oppose with amendment, which is where I would be leaning, is actually using the state's own definition that we were carved out as essential services. So in the definition saying, carving out the BBS, which is recognized by the state as an essential service, which also has policies in place to create waivers, something along those lines, but to bring in this idea that we as our profession have already been carved out of by the state as people who had to be on the front lines and had to be available to provide services to the community. I think that might give a little bit more weight to why we feel so strongly about needing this carve out for the BBS.
Okay, Wendy.
I was just going to ask what others might think about attaching something about, unless they're going to provide some sort of supplemental funding for it. So like if the state were going to offer some of their federal funds or general funds to, supplant the board's budget, then I think, some of these concerns, I'm not saying whether that's likely or not, but, if the state if the legislature feels strongly about this and they want to make it a budget item, I think it might be a different conversation. So could we tie something in there about, if they're going to provide funding for it, just food for thought.
Can I go to the public comment now? Is that good? Okay, Ben, it's all yours.
Good afternoon, Ben Caldwell, MFT. So everybody seems to agree that the bill is well-intentioned, and it sounds like the major concerns are about, if an emergency, whether this or another, is severe enough, what the impact on the board and its ability to provide services is going to be. I might suggest that that is a solvable problem, and you can do it by adding 2 things to the bill. One, as Deborah and Wendy suggested, is to have them include strict eligibility criteria. I mean, the bill, I think, is intended to help those who, it's not a question of whether they pay their fee or don't pay. It's more a question of they're not going to pay because they're not going to have the money. So do you allow them to remain licensed or not? So if you include requirements such that the person has to document a severe financial exigency as a result of the state of emergency, that should limit the sort of liability on your end in terms of how much risk there is. The other thing to ask to include is some kind of a backstop, some kind of a limit to say that the waivers under this bill that the BBS would be responsible for are limited to a certain percentage, maybe 5% of your annual operating budget. That way there is no possibility that there's going to be the kind of devastating and overwhelming event that a number of you have rightly expressed concern about. There wouldn't be the issue of so many people requesting a waiver that you're not able to provide fundamental services. So I think it's possible if you wanted to, and I think again there's agreement that it's a well-intentioned bill, to go the support if amended route in a way that really does protect the board's ability to do what it does. And that way you can have the benefit of the bill without some of the risks that you're rightly concerned about. The only other thing that I would mention here briefly is that the bill talks about deferral of payment rather than waiver of payment. And for people who are really going through a severe financial exigency, a waiver is better. I don't know that adding another debt onto what they are already experiencing is in their or your interests. So it might be worth talking about waiver instead of deferral. Thank you.
And we have a comment from Leah.
So 2 pieces. One is I'm hesitant to put a percentage on because it becomes a first come, first serve situation. And I think about how that might end up being inequitable for underrepresented people somehow. I don't know. I just get nervous about doing that and then just saying, okay, it's 3% and the other 90% of you or whatever are just out of luck. So I like the idea that they do need stricter language, and I think we should give that feedback to them. But I'm actually still sitting with oppose unless amend, and I would like to call the vote.
So if we're going to call the vote, can we just go over what amendments are included in the motion so we're clear?
Absolutely. Who has the motion written down very clearly? Anybody?
So far I just have, let's see. No, I don't.
I thought it was just, oh no, it was an exemption, trying to get the just a plain exemption. And then you guys brought up a couple ideas for the letter.
Mm-hmm.
The ideas that I have to remove BBS, state that we're essential, and given our fiscal condition, it's not feasible. We already have something in place, or we could mention something about, there's already the regulations that we plan to pursue that allows us to do this in order to assist in exceptional circumstances.
And ability for waivers during the states of emergency, possibly, like we did.
And this is just for her letter. This isn't for the motion, right?
Correct. Right.
And I like Ben's point about the concern of not having strict standards written in the bill. I just think that's good feedback for them.
Mm-hmm.
So Roseanne, do you have what you need?
Yeah, let me read it one more time. The motion would be to oppose unless amended to remove the BBS. We would state that our board's services in the current pandemic have been deemed essential. We've had the opportunity to have waivers in the state of emergency. Our current fiscal condition couldn't support it, and we already have a mechanism in place from last year's law that allow us to run regulations to assist in exceptional circumstances.
Mm-hmm. Okay.
All right.
Did we have the motion then in second?
Yes, we did.
Okay.
Okay, ready for the vote?
Comments look like they're pretty clear right now.
Okay, here's the vote. Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Disposti?
I'm abstaining.
Susan Friedman?
Yes.
John Sovek?
Yes.
Wendy Strack?
I'm going to abstain.
Okay. And Christina Wong?
Yes.
Okay, motion carries.
Okay. Now we're going on to.
Okay, our last bill for the day is SB 1474. The author of this bill is the Senate Committee on Business and Professions and Economic Development, and the subject is business and professions. And this is kind of an omnibus bill. A lot of different technical changes for different boards. For our board, the provision of the bill we're interested in is that it would extend the board's sunset date for 1 year until January 1, 2022. There was the potential that our omnibus bill, or every year the board sponsors an omnibus bill, and the Senate Committee on Business and Professions runs it. They were going to potentially put that in this bill. However, due to the COVID-19 issues and priorities, they've decided they're leaning toward very strongly that we won't be running our omnibus bill items that we approved last November this year. So those will likely have to be run next year, but we did want to get a position on the extending the sunset review because that is obviously going to allow us to continue to function. So we were scheduled to have our next sunset review, as we discussed early in March 2020. However, that's all been pushed out to next year. So this bill would allow us to continue to operate so that we can have a sunset next year. So we can discuss that.
Okay. We have a comment from Christina.
I am taking a big jump of leap of faith that I'm going to make a motion to support the bill.
And I'll second that.
Okay.
It's a no-brainer.
Okay. There's no other discussion at comments yet. I don't see any comments.
And actually, just to make one technical change, the motion should be just to support that particular provision of the bill that extends our sunset date, not the other stuff.
I will make I will amend my motion for what Roseanne just said.
And I'll still second it.
And we still have no comments.
So support the provision to extend the sunset date of SB 1474. Does that sound good? Okay. Okay, so no comments. Ready for the vote? Crystal Anthony?
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Disposti?
Yes.
Susan Friedman?
Yes.
John Sovek?
Yes.
Wendy Strack?
Yes.
Christina Wong?
Yes.
Motion carries.
All right, my last item for today is the legislative update. So the board was pursuing 3 legislative proposals. Obviously, we've had to make some changes due to the extraordinary circumstances due to COVID, so I'm going to give the status on each one. We had AB 2363, our practice setting definition bill that would have provided the specific definitions of private practice, professional corporation, and non-exempt settings. Due to the COVID-19 state of emergency, all legislators were asked to prioritize and pare down significantly their bill proposals to accommodate a shortened session. The author informed staff that they would not be able to move forward with this bill proposal this year, so we will need to pursue that bill proposal next year. AB 2142 was our fee bill, the fee to increase the licensing, registration, and exam fees for our board. We were advised that DCA was going to be running a trailer bill with that had all other boards that needed a fee increase. The language was all going to be placed in there. So it was recommended that we move that language to there. It has not been formally introduced at this time. The trailer bill language works a little bit different than the regular bill, but DCA is working to get that in print as far as I know, and that language will be moving forward in that trailer bill. And then finally, SB 1474 that you just took the position on regarding our sunset extension date. There were supposed to be our omnibus bill, minor technical amendments to add clarity and consistency to our licensing law. That at this time we've been informed that it's unlikely that they will amend that into this year's omnibus bill. Those will likely have to be pursued next year. So that is the legislative update.
Okay. It looks like Christina has a comment.
I just want to, the budget trailer bill, that is really, that's a kind of like a new term for me. So I'm just wondering in that sense, if, what is the, will that trailer bill be in part of this legislative cycle, and if it's signed by the governor, and it will still be in effect on time, right?
Yes. So what it's not uncommon. Every budget every year has trailer bill language, and so it just moves as part of the budget package through the legislature, and then it all goes to the governor in one package. And so if he signs the budget, the trailer bill language gets signed too.
I just want to make sure that, the board, is able to operate with the fee increase. So thank you. Thank you, Kim.
And a public comment from Rebecca.
Becky Gonzalez, NASW. I just wanted to point out that the Assembly floor report on the budget recommended deferring this issue. So I don't think this is a done deal until the legislature comes to agreement on the budget. So I just wanted to point that out.
looks like I have no other hands raised. So should we
Move on to Christy? Yeah, Christy, I think it's you with item number 24.
Thank you. So this has to do with the board supervision regulations. Back in November 2019, the board approved some regulatory language that would change requirements pertaining to supervised experience required for LMFT, LCSW, or LPCC licensure. And some of the key provisions are creating consistency in the supervisor requirements and responsibilities among the 3 license types, setting some standards for documentation when a supervisor dies or becomes incapacitated before they've signed off on experience, requiring supervisors to notify the board that they are supervising and that they meet the qualifications to supervise. Now, currently, we don't know until after when somebody submits their experience that they've been under supervision. Requiring supervisors and supervisees to sign a supervision agreement. Some things about how supervisors monitor and address dynamics, temporary substitute supervisors. We've made some adjustments in the training requirements, initial and ongoing professional development. We addressed some situations where a supervisee is working, having been placed by a temporary staffing agency. We've allowed proposing to allow supervisors who hold a certification from certain entities to be exempt from certain qualifications, and then clarifying some aspects of supervision gained outside of California. So this proposal was noticed to the public on February 7th, 2020. We had our 45-day public comment period, which ended on March 23rd. We held our public hearing online, the first time we've done that. And we have a lot of interest. So I do have a transcript of the hearing. I have a summary of all the comments received both at the hearing and in writing. Unfortunately, the written comments that we received, the actual letters and emails, we attempted to post them with the meeting materials, but unfortunately they were not able to be made ADA accessible. So if anybody would like a copy of that, you can request it. Let us know, send us an email, and we'll get that to you. But I do have a summary here of all the comments that have been received. So I'm going to go through the comments and our proposed response. And I think what I'll do is stop after each of the comments to for the board and maybe take comments on the proposed response. So the first set we got very similar comments from several individuals at the hearing, and they were very similar. So each had to do with they would like the regulations to be amended to allow for supervision via video conferencing in a private practice setting. Right now, it's only allowed in an exempt setting, although we did get one of the waivers that the board got does now allow it temporarily due to COVID. So, so they gave some, rationale for that. But we rejected the comment because it's the actual statute that says, and not regulations. So the statute supersedes any regulations. So it would have to be a statutory change to allow for that. So it would take legislation. So it's not a change that we could make through regulations. And on top of that, we would need to have some quite a bit of discussion about allowing that in the future in a private practice setting. So I'll stop there and see if there's any comments, any discussion. Oh, I can't hear Steve.
Wow, I'm bad now too. No comments right now.
Okay, thanks. Okay, so the second comment was from an individual who would like to see telephone conferencing allowed for group and individual supervision because some may not be able to access even telehealth equipment. So we are rejecting this comment as well. It's the same reason the statute requires it to be face-to-face. So it would have to be pursued via legislation. Any comments there?
And doesn't look like there's any comments.
Okay. Then I got a comment. This person submitted one at the hearing and then later in an email on 2 different topics. Commented on the portion of the regulations having to do with a deceased or incapacitated supervisor. He suggested that the regulation include directives for the handling of supervisory documentation in a professional will. We're rejecting this comment. This is our proposed response. So we propose that that we reject this comment as well. We feel like this would be better addressed in a larger discussion about professional wills for all licensees and not just supervisors, and whether it's even appropriate to require them by law.
And no comments?
Comments, okay. Second comment from the same individual, he requested that certain subsections be stricken from the proposal. Those particular provisions would allow supervisors to count supervision-related mentorship or consultation and attendance at supervisor peer discussion groups for their continuing professional development hours. So the continuing professional development is something that is replacing where they used to just have to do continuing education. So now it's continuing professional development. CE can be part of that, but these other mentorship, consultation, and peer discussion groups are now allowed. And his reasoning was that they may not meet the rigors compared to CE. Peer groups without CE may be helpful and provide insight, but can become unstructured and maybe not have a lot of education, and that it feels that it's counter to the board's. He's referring back to a bill that removed, changed the hours of experience that are allowed to be counted for LMFT. They used to be able to count personal psychotherapy. So he feels like the fact that we no longer allow that kind of is a reason for why maybe, trying to explain here what he's saying, but I think he's saying it's counter to that. We're proposing to reject this comment. These newly proposed activities were discussed at great length at the board's public supervision committee meetings and had really broad support from stakeholders. And as I mentioned, currently CE is the only thing permitted to meet this requirement, but CE may not meet a supervisor's specific development needs, and quality can vary in any of those activities, including CE. And we feel that if quality is a problem, the professional can find a new group or a new mentor or a new course. The other thing to remember here is all new supervisors have to take a one-time 15-hour CE course when they first become and this continuing professional development is 6 hours every 2 years. In addition, every licensee has to do 36 hours of CE every 2 years. So it's very likely that many supervisors will continue to meet the professional development requirement by completing CE as well. So, any discussion on that one?
We do have one, Leah.
So I just would add to that, Christine, I've been thinking Christina, that it is up to the supervisor to demonstrate the rigor of those meetings, and then the staff can evaluate whether it's effective. So if they're just saying, here's a signature thing, we met 10 times, I don't think the board is going to accept something quite so flimsy. So I don't know if it's helpful to make sure that this person understands that the board will expect the individual to demonstrate how useful it is.
I'm not sure the regulations have that component to where they would have to demonstrate it to that level.
Okay, then never mind.
I think in the supervision committee, it was kind of a professional judgment. They're submitting that and signing off that they did the course. So it's really to their detriment if it's not. And they've already been required to take the course, the courses at the beginning. So they're really attesting that, hey, I did this, and it was
No additional comments? Nope.
Okay. And the next comment was, this gets a little bit technical, and I think I saw that Jerry is here. On the.
Who was he? It doesn't
He was
appear.
here.
Yeah, he's not.
I understand. So this, but if he's there, hopefully he can explain a little better. So he was. His comments pertain to the section that requires, and it's already required, is the written oversight agreement when you have a supervisee with a supervisor who do not have the same employer. So right now they have to have a written agreement that specifies certain things. Part of it is making sure that the supervisor has access to the client records, and making sure that the supervisor is able to, guide the supervisees and provide them with direction, despite not being an employee of that agency. So he was suggesting that we add the term employer so that we say this agreement, an oversight agreement, shall contain a statement from the supervisor and employer agreeing to ensure the extent, kind, and quality of counseling performed by the supervisee is consistent with the supervisee's training, education, and experience, and is appropriate in extent, kind, and quality. So we're proposing to reject this comment. While employers have a role to play in ensuring the quality of counseling, it's really the supervisor who has the primary responsibility, because they have the direct knowledge of of that client-therapist relationship, as well as the therapeutic model and the techniques being used by the supervisee. And again, that primary purpose of the written oversight agreement is to ensure that the employer allows that supervisor to fulfill their responsibilities as a supervisor. Any comments there?
No comments.
No comments, okay. And the second comment was a suggestion to delete a repetitive section, but I didn't see that it was repetitive, and I had Roseanne look at this one as well. We didn't see that there was didn't seem to have any repetition, so it has to do with language about the extent, kind, and quality of counseling. So we don't believe, this section that he was requesting that we delete, it pertains to a supervisor's responsibilities, that section A2. The other subsection pertains to an employer's responsibilities and provides some important protections. So again, he's looking to make some language consistent and to delete some repetitive language, but that change would again affect where the employer and the supervisor's roles kind of get mixed up, and so that's why we're proposing to reject that comment.
And doesn't appear to be any comments on that.
Okay. The last comment that we got was had to do with licensed educational psychologists. There was just a concern that, or just a question really that came in, but I wanted to make sure it was included in the comments, that LEPs were missing from the overview of the regulation. And what that's referring to is there's two documents. When you propose changes to regulatory language, there's two documents. One is the initial statement of and one is the public notice. There's two separate documents. And while LEPs were mentioned throughout those documents in a certain paragraph under each of those documents, they were not included. So they just weren't mentioned. So upon receiving this question, we immediately responded and we updated our website. We couldn't change those two documents. What we did was updated our website to just be clear that LEPs were included in these pending in this proposal. So again, it's included throughout the documents. It was just one paragraph were not mentioned, so that created a question. So any comments there?
No comments.
Okay.
Oh, wait, we do have one. Yeah.
No, I just want to make sure there were no comments. So do I need to make a motion to accept the language as written and direct staff to make any non-substantive changes to complete the regulatory process? Or what do I do, Sabina?
Read you something. So if you guys like the responses, and your motion can be to direct staff to reject the proposed comments, provide the responses to the comments as indicated in the materials, and complete the regulatory process as previously authorized. How about that?
Okay, that's my motion.
I'll second that.
Sabina, can you email that to me? Thank you. Oops, where'd it go?
Sabina, there was one comment that was accepted, comment 7, so we want to note that too.
Yes.
Oh, yes. So I should say to reject and accept the proposed comments as provided in the materials.
Okay.
Call the vote.
Yep. Sounds good.
Ready for the vote?
There's no comments, so yeah.
Crystal Anthony? I couldn't hear. Crystal?
Sorry. Can you hear me?
Yes, I can hear you now.
Yes.
Dr. Leah Brew?
Yes.
Deborah Brown?
Yes.
Betty Conley?
Yes.
Max Disposti?
Yes.
Susan Friedman?
Yes.
John Sobek?
Yes.
Wendy Strack?
Yes.
Christina Wong?
Yes.
Motion carries.
Okay. Next agenda item. Betty.
Christy's still on with item number 25.
All right, so this is an update on our rulemaking proposals. The first one is our AB 2138 regulations. I'm going to actually let Roseanne fill you in on that one.
Oh, Roseanne, can you?
All right, so our AB 2138 regulations, we've been going back and forth between us, legal, and OAL, trying to get a finalization of the language that is acceptable to OAL. They've done a courtesy review of it and had some feedback. So we're looking to, right now I'm working with our reg attorney to try to satisfy those comments that they requested. They requested some things that kind of surprised us a little. So we're working with that. The next step is once I get that finalized, legal will need to see if it needs to come back to the board or not for another review. Depends on whether or not the changes are substantive or not. So we're diligently working on that. It's just a very complex process. We're either the head in the lead in terms of other boards on this, or there's just a couple that are at the same level as us in terms of finalizing these. So being one of the first, it makes the process a little harder because OAL, is going to be approving about 30 of these. So we're kind of the trailblazers, or one of the trailblazers on this. So it's taking some time, but we're making progress.
Oh.
Okay, so our next regulation package has to do with updating disciplinary process and making updates to our uniform standards document. And that is on hold until the 2138 regulations pass, because it has some things that are affected by those regs. We have regulations that have been recently approved by OAL and take effect July 1st, 2020, pertaining to exam rescoring, application abandonment, and subsequent associate professional clinical counselor registration fees. They're all very technical amendments. So it's just some clarifying issues. So those are going to take effect July 1st. Our supervision regulations are the ones that we just discussed. So they are, the next step for that will be to start the final review process through the department and agency. And then once it passes through that process, so that usually takes a few months. And once that is completed, then it goes back to OAL for final approval. We're hoping for a January 1 implementation date or approval date. And so we'll see how that goes. Our continuing education and additional training requirements regulations, those have, so the board approved those back in November 2019. Those were, have been through, so that we prepared all the documents. They went to our legal counsel for like a pre-review process. So the next step is to get them into the DCA initial review process. So I'm working on preparing it now that I've gotten feedback from counsel. So we're expecting that to start that process here soon. The other regulations that have been approved by the board that are pending are the examination waiting periods, professional corporations, and accrediting agencies and equivalent degrees. So these are some really technical changes that affect those areas, and those are in preparation for the initial review process as well, preparing the documents there. So that's what I have for regulation update.
Okay. Thank you, Christy.
You're welcome.
Any comments from the board on?
Doesn't look like we have any comments.
No. Okay. Then we're going to move to public comments for items not on the agenda. And Steve, it's going to be you because I can't see everyone.
No, got it. Rebecca, please go ahead.
Becca Gonzalez, NASW. I just wanted to comment on AB 1850, which was pulled from the agenda today, just to know, so you can know where we are on this legislation. AB 1850 is a follow-up to last year's 85, which defined who could be an independent or who could continue to be an independent contractor, and it did not include the board's licensees, so that it stopped them from being able to being independent contractors. We have heard from a lot of our members who are very unhappy with this because they want to have the choice. There are many people who want to work independently, not to have an employer, to work when they want to. And also, I think for social workers in particular, there are a lot of agencies, nonprofit agencies that serve low-income communities, racially diverse communities, and they really use the independent contractor model, and it works for them, and it would be very expensive for them to bring people on, to bring everybody on as employees. So we're continuing to work with the author of AB 1850 to hopefully exempt our professions from the provisions of that bill. Thank you.
Okay, Jen. All right.
Oh, you startled me when you called my name. I jumped.
Sorry.
I have I have three things to talk about. One, I'd like to, echo some of the comments about AB 1850. CAMP continues to receive calls on a regular basis about our membership, looking for some sort of solution, because they do prefer to work in some cases as an independent contractor, and not so much that we don't support or agree with, the employee protections that were contained in AB 5. We just think as a restricted class, with having, higher degrees and license requirements and going that extra step, that we're not, necessarily in the same class of individuals that bill sought to protect. And so we continue to, meet with the legislature and are looking for a solution. The second item I wanted to bring to the board's attention, CAMP is working on a letter, and the board will be CC'd on it, regarding Talkspace and similar companies that allow for psychotherapies to delivered through telehealth. The company has been advertising or encouraging, our members, and I'm sure other board licensees to sign up and provide care. And sometimes our licensees would be providing care in other states. And so we're concerned with how that could jeopardize our license. And so we had that letter drafted and ready to go prior to COVID. It kind of got put on the back burners. You know, we had to shuffle our work priorities. So that should be coming to everyone very soon. And the last things that we continue to receiving feedback for our members for regarding is for the associates, you know, working under option 1 and option 2 on how they can, you know, finalize their hours. And we appreciate the concerns that the pre-license that are having being impacted by, you know, changes that are going to go into effect in December this year. And we understand that it's not likelihood that, you know, the old way is going to continue. But we just wanted to kind of bring that to your attention and wonder if there would be any way that maybe the board could put out an FAQ on this issue or something along the lines of how that is going to continue, just so we aren't, you know, continually cutting and pasting your emails and documents that we send out to our members. So that's all the issues that not on the agenda that I have to comment on today. And thank you very much for your time, and I appreciate your ear.
Kim?
Yeah, I just very quickly to inform everyone, Max had to leave due to an emergency. Apparently there's a very large protest right outside his office. So we still have quorum, but I wanted to let you know that he had to abruptly leave.
Okay.
Any
other hands raised? So
no.
Nope.
Well, are there any suggestions for future agenda items?
And I've got
Leah.
2. Yeah.
I have 2 items, Kim. First, I think we should talk on a future agenda about adding LEPs to the portability law, since now there is another state. And then secondly, based on one of the comments we heard, it might be good to have a discussion whether or not we want to have supervisors or require supervisors to have a will in the event of their death or incapacitation. I think it's worth a conversation. Thanks.
Okay. Rebecca?
The other issue since this whole stay-at-home order happened that we have been receiving a lot of communication with our members on is the issue of out-of-state therapists who had their the person they were working with moved back to California temporarily, most typically a college student, and being able to continue to perform those services to provide that continuity of care. I don't think I'm proposing that they get a California license, but I do think there should be some provision for temporary services. I do know in the Board of Psychology, they do have a 30-day temporary provision of services clause. I don't know if you know, we should exactly model theirs, because it doesn't say anything about a state of emergency. It doesn't have those qualifications, but I really think it's something that's worth looking into, because we have received a lot of calls about this issue.
Roseanne?
Just to piggyback on that, the board will very likely soon be establishing a telehealth committee, because this has enlightened us to some law changes needed regarding telehealth. So we are very aware of those issues. So stay tuned for more.
Mm-hmm. And then Jen?
I did not mean that was an error. My apologies.
All righty. Well, I'll take that down. Jan Lee. Jan Lee?
I'm here.
Oh, there you are. Okay.
Sorry about that.
No problem.
First of all, thank you all very much for holding this Zoom board meeting. It's really a challenge these days. You guys have done a great job, because it's not easy to do your full agenda, and it's certainly not easy to do it first time on a Zoom platform. So thank you so much. You probably can tell the access has been dramatically increased because we attend board meetings, and sometimes there's just a few of us, you know, Jen and Rebecca and I and others, and you had a larger attendance due to the Zoom platform. And that's one of the advantages. What I do want to bring up is that someday, sometime in the future, the board might want to have a presentation on how to be an anti-racist. And I pledged our organization and our efforts to really try to be anti-racist. It's not enough to say you're not racist. I've said that my entire life. And you look back now and you say, what have we accomplished? What progress have we made? And why are we currently at the state of affairs that we are? Now, I know some feel that this is too political and they don't want to go there, but think of all the trauma, all the mental health issues that have arisen because we're not where we should be. And if that's your mental health connection or link to this, so be it. But there are several groups out there that can do a really good job on how to be an anti-racist. So I encourage the board to consider having such a presentation sometime, someday in the future. Thank you.
Thank you.
And Betty, that looks like all the comments we have.
All right. Well, with that, I would like to thank all of the board members who have hung in there. This was an unusually long day without even a proper lunch break. So thank you to all of you for hanging in and doing such a wonderful job. Thank you to the board staff. Thank you to the stakeholders that have also hung in there for a very long day. It was incredibly productive, even with our technical difference. Anyway, thank you to all of you, and have a great weekend. With that, we are going.
One more comment, Christina.
One more comment.
Do you have a comment?
I do. I want to just thank Betty for being our chair for the last couple years. And this is your last board meeting, so we want to just give you a round of applause.
Oh, thank you all.
So you cannot leave without us, you know, giving you a big kudos.
Thank you very much.
Could I say something? I didn't get a chance to say anything to Betty earlier. Betty, you have been so great to work with because I've worked with you for the last 4 years. And I just want to say thank you so much. And you are another one on the board that every time I approached you and said, will you help me? There wasn't any hesitation in your voice. It was, yes, what do you need? And just as the past chair for the 2 years, you were instrumental in getting so much work done. And thank you for your undying commitment to this board and willingness to help out.
Oh, thank you. Thank you, Deborah. I really appreciate that.
Definitely. I'll echo the sentiment. But somebody else around here has a little bit of news. Something is occurring at the end of this month, Mr. Jan Lee.
Oh, yeah.
Yeah. So Jan Lee is retiring at the end of this month. This will be our last meeting with you, Jan Lee. I just personally want to express my pleasure in working with you. It's been a great partnership. I've learned a lot from you. You bring a lot to the table, and best wishes for your next adventure.
Thank you very much. It's actually end of July, but my board has asked me to consider staying on because of the multiple crises that we're in now. Of course, we expect a second surge or a third surge of COVID, especially based on what's going on, and no social distancing, no protections. People are not practicing those things because their issue is so important right now. But we'll see what happens. They're on a search for someone. I don't know if they'll find someone, and I believe so much in this work that I can continue if they don't find someone. But nevertheless, it would be nice to ride off in the sunset.
I agree.
It's a soft retirement, right? It's a soft day, and you really, it's not set in stone yet.
Well, congratulations. Congratulations.
Yeah, awesome. Okay, all yours, Betty.
Right.
And I want to thank Jenny for just that unique and wonderful comments all the time. You kind of like, keep us in check when we're like going that, direction and go, wait. And so, I just really appreciate, your comments and always, the courage to say something, very different. And so, I learned so much from you, and, and I just really value, your contribution to the board and representing NASW to really uphold the principles and, and the, to protect the social workers. So thank you so much.
Thank you, Jen Lee.
And I'd like to echo that, Jen Lee. It's been a pleasure working with you. I've learned a ton from you, and it's been great having you to work with. So thank you.
And I don't know what we're going to do without Jan Lee saying 20 years ago, this was a discussion, because he is definitely the historian of the board, and nobody else could do that.
Yes, invaluable.
Yeah, I would also want to say, Jan Lee, I'll miss you. I think you and I together probably have the most history, having going back. I think I remember some very early board meetings with you back in the early 90s, I think is when I first started going. So it's best of luck to you, and it's been great working with you.
I think we will miss a lot of institutional knowledge.
Yeah.
Who's going to explain what 1099 is for, right? Let's look at the tax law.
All right. Well, everyone, thank you. Maybe I'll see you at the next board meeting. I don't know. We'll see what happens, depending on if we can get some new appointments in. But it's been a pleasure. And with that, thank you all for your hard work, and we will see you soon. Have a good weekend.
Great. Thank
you.
Thank you.
Bye, everybody.
Bye-bye.
Thank you, everybody.
Bye.